everyone. Very excited to have you here. Today we're wrapping up the JGLS Insolvency Law Lecture Series 02 with Emma Vici. Very excited to have her on board. And I'm also very excited that you stayed with us throughout the 5 lectures. Now, this particular lecture is a special one because the word that is thrown around for discussion and conversation at the moment is prepackaging and group insolvencies and how they kind of pan out. For those of you who've listened to our earlier lectures, you would have noticed a lot of emphasis on how they are differently defined in jurisdictions such as Singapore and the United Kingdom, both common law jurisdictions. And one of the things that is very important for us to have a chat about is the complexity and the multi-dimensional definition that has been provided to prepackaging and prepackaged insolvency in certain other jurisdictions, which is where Australia comes in. Now, Emma Vici practices in areas of domestic and cross-border insolvency, banking and finance, and commercial litigation. She's a barrister with New Chambers Australia. She's an Insol Fellow and a lecturer for the Australian module of the Insol Foundation Certificate course in International Insolvency Law. I've had the privilege of doing the course and having her as a professor for the course, and it has been a fantastic learning experience. She's also a member of the Turnaround Management Association, the Australian Restructuring and Insolvency Association, and the Banking and Financial Services Law Association. To cut short the accolades, I want to very quickly talk to you about the briefs that Emma has appeared on, particularly the group insolvency briefs that she's engaged with. A sense of how that engagement has panned out is something that we're going to talk about when we get to some of the questions that we're going to ask as a part of this session. These include the collapse of the Arium Group, the collapse of Courtney House, Cyrus Capital in its Virgin Australia bid, Thai Airways and the Australian issues in its Thai business reorganization, and other corporate groups, including COVID-related restructuring proceedings. Now, without giving you more background, which I'm sure you've already Googled, I want to ask the first question to Emma on the basics. Now, what are the various corporate insolvency laws in Australia, Emma? Now, our theme for today and the topic of our lecture today is schemes, deeds, prepacks, and group insolvencies. In this kind of context, could you give us a short history lesson on the various laws, their use and processes that are available to creditors and corporate debtors? Now, a lot of the times, the conversation in my classroom particularly is about whether it becomes creditor in possession, debtor in possession. And these are the two words that are often thrown around, and to separate that from creditor-driven becomes a task and an important kind of exercise in setting the tone of a lecture. Let's talk a little bit about what kind of regime Australia is, schemes of arrangement in Australia, and how often these schemes of arrangements are used as restructuring tools. And without further ado, I want to invite you to take the first question and start this lecture.
Thank you, Ishana. So Australian insolvency law has its roots in English law, as you'll all be familiar with. We've had liquidation regimes for companies since the mid-1800s. And then when Australia federated into a single nation in 1901, we had a liquidation framework, and we also had a receivership framework. I'm sure your students will know that a court can appoint receivers to organisations, whether they're companies or not, to the assets of those companies. But more importantly, secured creditors can appoint receivers and managers over all of the assets of a company. if the company has granted security over its assets and then it defaults on its loans. That receivership power is a critical one in Australia because Australian banks still use that as their main enforcement mechanism in their corporate lending. Now, once a receiver and manager comes in, they have complete control of the management of the company, and they do that for the purposes of recovering the secured debt. So those are our two original forms. Schemes of arrangement came into Australia in around the 1930s. They'd been in the UK for 60 or so years before that, and then we brought them over to Australia. Now, what we're talking about here is creditors' schemes of arrangement because we're talking about an insolvency context. And the way a scheme of arrangement works is the company comes up with the scheme they want to propose. They prepare some scheme documents, then they go to an initial court hearing. And at that court hearing, they get some orders about convening meetings for the affected creditors. And then they hold those meetings, and at those meetings, the creditors vote on whether to approve the scheme. Now, the creditors vote in classes, depending on how the scheme is going to affect them. And they need, for the scheme to be approved, they need a supermajority in each of those classes. Now, the role of classes in schemes will become important for you to understand when we then talk about the later forms of insolvency that we've developed in Australia. After you've had your approval in your scheme meetings, you come back for a second court hearing. And then if the court approves the scheme at the second hearing, and at that second hearing, the court looks at whether the scheme is fair and appropriate. If the court approves it, then your scheme becomes effective. And usually the existing management of the company continues on managing the affairs of the company, possibly with the help of a scheme administrator who may deal with some aspects, but essentially the existing management gets to continue on to implement the scheme. Now, if an insolvent company has already entered into one of the other forms of insolvency, voluntary administration or liquidation, then the administrator or the liquidator can propose a scheme of arrangement themselves as a way of bringing the company out of that insolvency process. And in those instances, it'll then be the administrator or the liquidator that retains that management control of the company. The downside of schemes is that they're slow and they're expensive. They'll take at least 3 or 4 months to go from the original idea of preparing a scheme through to approval of the scheme. And because they're costly and slow and a bit unwieldy, they're rarely used in Australia, but they are used for the largest and most complex corporate groups because they provide solutions that none of the other mechanisms can really provide. Now, we've had schemes since the 1930s. What happened next? Well, we got a uniform law model, a uniform law for corporate insolvency across Australia in the 1960s. And then in the 1980s, there was a review of liquidations and schemes of arrangement. And it became quite evident at that point that the tools were too unwieldy and they weren't fit for purpose for restructuring. So the Law Reform Commission recommended a voluntary procedure, a wholly new procedure whereby the property and the business of the company is preserved for a brief period of a number of weeks. A voluntary administrator investigates the affairs of the company, and then the creditors are asked to make an informed decision about whether they wind up the company or accept a compromise. Now you can see in the chart that I've put up, I've told you a little bit about receivership, very little about liquidation because we already know about it. And now we're looking at voluntary administration, which sits in the middle. It can lead to an insolvency type outcome or to a restructuring type outcome. But it's still a creditor-driven process. Now, the way a voluntary administration works is the the directors resolve that the company is either insolvent or likely to become insolvent at some future point in time, and they appoint a voluntary administrator. And that voluntary administrator needs to be independent and a qualified insolvency practitioner. Now, that criteria that the administrator be independent is a really important one when it comes to considering whether Australia can really do prepacks. So I'll come back to that when we get to prepacks. So the voluntary administrator has to hold a meeting for all of the creditors within a week or so. And at that meeting, the creditors can vote to replace the administrator. They rarely choose to do so. The administrator then spends a few weeks investigating the company's affairs and reports to the creditors on the alternative options that are available. They hold that second meeting of creditors about 4 weeks later. So it's a fairly swift process. And at that second meeting of creditors, the creditors vote on whether to put the company into liquidation or to put it into a deed of company arrangement. And the deed of company arrangement is normally just called a DOCA here, and it's our primary form of restructuring agreement. There is a third alternative. The creditors might vote to return the company to the control of its directors, but that's very rare because what we're dealing with is insolvent companies. None of the creditors want the directors taking over again. Now, it's not necessary for the court to be involved in that process at all. The court involvement will only occur where a creditor wants to challenge the process or when the voluntary administrator needs some specific order from the court, like an extension of time or protection from a certain type of liabilities. The voluntary administrator in this process becomes personally liable for debts incurred by the company if it continues to trade. So there's an incentive for suppliers to continue to provide goods and services to the company so the company can continue. And there's a very strong incentive on the voluntary administrator to make sure that they only trade on if they think there's a good chance of bringing the company back to a good financial position, because otherwise the VA will be personally out of pocket. One important thing to note about DOCAs is that they don't bind secured creditors, unlike schemes of arrangement, which can bind secured creditors. Now, finally, secured creditors can place a company into voluntary administration, but they rarely do so here in Australia. They prefer to appoint a receiver and manager. And liquidators can also place a company into voluntary administration if they see a real possibility for a DOCA, but again, that's fairly unlikely. Now, before I tell you about the latest developments, which you'll see on the diagram is the small business simplified debt restructuring on the far right and the small business simplified liquidation in the middle. I wanted to talk a little bit about Australia's creditor protective philosophy. So we traditionally have what has been described as a creditor in possession style insolvency model. And you can contrast that with the US debtor in possession model. What that means is that for almost all of our insolvency regimes, an independent person comes in and takes control of the company away from the owners and gives that control to the creditors through the administrator owing all of their duties to the general body of creditors. So you'll see that all of the boxes in blue on the diagram are creditor-driven, creditor in possession, and the two on the right, the scheme of arrangement, which we've already talked about, and the small business simplified debt restructuring, which we'll come to in a moment, they're the only ones that are debtor in possession. We can probably take down the diagram now. Now, historically, Australia has been seen as very tough on directors, perhaps too tough. We have very strict insolvent trading laws, which impose personal liability on the directors from the moment that a company continues to trade when the directors should have known that it was insolvent. Some piecemeal changes were made in 2017 and 2018 to try and soften Australia's creditor favouring regime and to make it possible for more restructurings to happen. A safe harbour reform was introduced, which allows directors to escape that personal liability for insolvent trading. But to do that, they need to obtain advice from an appropriately qualified restructuring advisor. So they need an insolvency practitioner to give them advice. And they need to be working on developing a course of action which is reasonably likely to lead to a better outcome than they would find in administration or liquidation. Now, this safe harbour reform, again, turns out to be very important to increasing the prospects of Prepacks working in Australia. Because without this sort of reform, the moment a company is advised or reaches the view themselves that they're insolvent, they stop trading and they put themselves straight into voluntary administration because none of the directors want personal liability. So we needed the safe harbour to even give us a chance of developing useful workouts for these companies when they're in that shadow of insolvency. Now, what hasn't been addressed until very recently is the fact that our system was one size fits all. All companies are eligible for voluntary administration and for liquidation, and they're in the vast majority of cases, they're the only solutions that are taken up, with the occasional scheme of arrangement for very large companies. That led to a perception that small business wasn't engaging early enough with the insolvency system, and that was reducing the prospect of these small businesses surviving. So the next thing that happened was COVID hit, and there had been some talk about some kind of small business reforms, but COVID hit and the government acted very swiftly to fast track insolvency law reform to better equip small businesses with some kind of affordable restructuring and liquidation options. So the new restructuring process, and it's back on the other chart, is known as the Small Business Debt Restructure, or the Small Business Simplified Debt Restructuring. It applies only to companies with under $1 million in liabilities. They have to have all of their employees fully paid, and they have to be up to date in lodging their tax returns. So the company that has fallen behind in paying its employees or has fallen behind in lodging its tax returns simply won't be eligible for a small business debt restructure. And that $1 million cap in liabilities is fairly low. So we really are talking about smaller companies here. But in the Australian economy, the majority of companies are small companies like this. So whilst these reforms won't hit the big end of town and won't affect their lives, it will affect the lives of a lot of small business operators. So the intention is that the reforms will allow the directors to keep control of the company while they work with an independent, appropriately qualified small business restructuring practitioner to come up with a plan to reorganise the company's debts. And then they seek creditor approval for that plan. Now, the small business restructuring practitioner doesn't come in and take control of management of the company. They just consult in an advisory role to the board of directors to develop the restructuring plan. And this practitioner doesn't take on any personal liability for the debts of the company. So the management of the company will need to be able to keep good working relationships with its trade creditors while it tries to come up with some kind of restructuring plan. This process draws on a lot of features of the US Chapter 11 model, and it's got this debtor in possession approach, and is a big change from all of our previous systems, which are almost all creditor in possession. As with the voluntary administration, this small business debt restructure is available to companies that are insolvent or likely to become insolvent. So if they're just wanting to restructure to optimize their arrangements or to reduce their debt, well, that's not going to be good enough. They have to be facing insolvency. A new simplified liquidation process was introduced at the same time for the same types of companies with less than $1 million in liabilities that can't be saved. Now, the new process is supposed to reduce the time and cost of a liquidation, but we're yet to see whether it actually turns out to be any simpler. And at the moment, there's some lack of clarity about the duties of a liquidator in a simplified liquidation and whether it will actually be any different to a normal liquidation. The same lack of clarity around the duties of the restructuring practitioner is evident in the small business debt restructure space. We don't yet know, and we're going to need to wait for some court decisions to tell us whether the duties actually are lesser duties or the same duties wearing slightly different clothing. So now that I've taken you through what all of the options are in Australia, I just wanted to point quickly to the statistics and note a couple of things. The most commonly used options in Australia, you can see from this, are liquidations. That's both the court ordered and the creditor's voluntary liquidations. These statistics are when a company first goes into some kind of form of external administration. This chart shows which route they take. Voluntary administrations are the next most often used, but you can see that the percentage of companies that take up the voluntary administration option has varied a great deal, from somewhere between 10 to 50% of insolvent companies choosing that option. And the trends over the 20 years of data that we have here, we've got fewer court-ordered liquidations, more creditors' voluntary liquidations, that is the directors resolving themselves that the company is insolvent and they have to liquidate it, and fewer voluntary administrations. And that decline in the use of voluntary administrations is one of the factors that informs the creation of this new small business restructuring option. What we find when we look further in the statistics is what happens after voluntary administrations. About 1/3 of voluntary administrations lead to a deed of company arrangement. The other 2/3 of the company goes through voluntary administration and then into liquidation. And finally, you'll see from these statistics that schemes of arrangement make up a very small number of Australian insolvencies, almost not statistically significant, somewhere between 0 and 5 of them in most years. But when they do come up, they tend to be the really big corporate groups that have an impact on a lot of people and a lot of financial interests. And they're not just one company, they're usually a whole set of companies that come together to form an interlocking set of schemes of arrangement to restructure them. So that is a whole overview of how Australian insolvency works.
Thank you for that, Emma. And it's also very interesting to see that there is a move towards voluntary in the early 2000s that actually is reduced over time. And also the fact that in insolvency, schemes of arrangement are not the most used option in Australia. It's a very similar trajectory for India in insolvency situations because of the number of stakeholders that are involved in the entire process. Now, from a recognition standpoint, I'm going to take a step further because we've obviously understood what the schemes are and how often they've been used in Australia. What in India, India as well as Australia and maybe across the globe, we're sort of witnessing is a recognition that one shoe fits all is not the way forward for insolvency, particularly. You know, different mechanisms need to be considered for different types of businesses. Hybrids, particularly, are necessary. And in this sort of setup, for India, particularly, prepackaged insolvency has been introduced as a debtor-driven process, a corporate debtor-driven process with a simple majority from the creditors, and for a particular threshold, which is vastly sort of different from how prepackaging is used in Singapore, for instance, or in the United States, where it is a part of the Chapter 11 process. Now, for Australia, what is the situation? What is prepackaging for the Australian regime? Let's start there. And are they possible?
Right. Pre-packaging is not part of our legislative framework at all in Australia, but we have some workarounds that make some sort of a pre-pack possible in some limited circumstances. And it's a field that insolvency practitioners here are very interested in. They'd love to be able to do more pre-packs, but our legislative framework makes it difficult. So the main reason that a true pre-pack is difficult to achieve here is because of our creditor-driven philosophy. So for voluntary administrations and deeds of company arrangement, the voluntary administrator has to be independent from the company. And that makes it very difficult for an insolvency practitioner to do the work that they need to do before the company goes into voluntary administration without putting themselves out of the running for the ultimate appointment because they become conflicted. So the result is that they dance a very fine line around trying to get a pre-pack, but not doing it too early so that they can retain the right to be appointed as the voluntary administrator. So once a voluntary administrator is appointed, they have the power under our Corporations Act to sell the company's assets before the company moves on to the next stage of either liquidation or deed of company arrangement. They have the power to do that so long as the sale is likely to result in a better return for creditors than is likely to be achieved in a liquidation. That power can sometimes be used to achieve something that's akin to a pre-pack. We have there's two case examples now. The first one is from 2000 in the case of a company called ISA Limited. And the court there held that the sale by the administrators of all of the shares in the company to one of the company's secured creditors before the second meeting of creditors had been convened was a valid exercise of the administrator's power to sell the assets. But even in that case, the administrators didn't do all of the work before they were appointed. So we're not talking about a true pre-pack where everything is done and arranged before the formal insolvency proceeding commences. We're talking about a part pre-pack. More recently, we had the very high profile collapse of Australia's second largest airline, Virgin Australia. And it was placed into voluntary administration. The administrators applied a few times to the court for extensions of the time to convene that second meeting of creditors. They bought some time and they had some financing to keep running this very large airline. And the government was willing to accommodate that because this was a COVID situation. During that time, they ran a sale process, a competitive sale process with multiple bidders. They got it down to 2 bidders. They eventually chose one. And then they reached a confidential agreement to sell all of the assets to the highest bidder, which was a company called Bain Capital. And they wanted to present this to creditors at the second meeting of creditors as a fait accompli. You know, here it is, it's been done. They weren't quite successful in keeping it under wraps because the other major competing bidder and a group of bondholders forced them into court and made them disclose enough about this deal for everyone to realise that the sale had already gone through and it couldn't be undone. And the practical effect of that was that the creditors at the second meeting were left with nothing real to vote on. they could either vote for a DOCA which made the sale to Bain Capital a little faster and a little more efficient, or they could vote for a liquidation. But either way, the whole of the business and its assets had already been sold to Bain Capital by the voluntary administrators. Now, this wasn't a prepack because the voluntary administrators negotiated this deal with Bain Capital after they'd already been appointed. But it does pave the way for prepacks in voluntary administrations, because it shows that that a voluntary administrator can go a long way in selling all of the assets of the company before you even get to a DOCA or a liquidation. So there's one limitation on that I'll come to in a moment. I noted earlier that the legislative reforms that created a safe harbour have increased the ability for prepacks in Australia. That's because it gives the directors some time to come up with a turnaround plan and to implement as much as they can a prepack transaction before they appoint a voluntary administrator. But in doing that, the company will have to be careful that the voluntary administrator they want to use is not too closely involved in the negotiation of the prepack. Because that voluntary administrator has to remain sufficiently independent to be allowed to take on the role. Now, in 2017, we had a decision in the case of 10 Network Holdings where the voluntary administrators had gone a fair way in their discussions with the company prior to their appointment and had assisted the company in exploring options to restructure what was one of Australia's major commercial television networks. But they did not go so far as advising or assisting the company with the prepack transaction. And it was the fact that they had held back from being involved in negotiating the prepack transaction, and that these potential voluntary administrators hadn't had any role in concluding any kind of a prepack. That was the only reason they were allowed to continue on to be voluntary administrators when their independence was challenged in court. So this case in 10 Network Holdings it's usually held up as the closest thing to a prepack case that we've had in Australia. But it didn't quite go all the way because the voluntary administrators were bound not to be too involved with this process. And until we get further reforms and an actual legislative framework that allows for prepacks, then the true prepack is not really a viable option in Australia. And there's no suggestion at the moment of any reforms to allow for true prepacks. I think Australia is happy to wait and see what happens in other jurisdictions and how it works out. And we're taking a very slow incremental steps towards any kind of a debtor in possession philosophy, which is built into the idea of a prepack. We've only just managed to get these debtor in possession regimes for tiny companies with less than $1 million in debt. I think it'll be a long time before we see acceptance that very large corporate groups should be able to come up with their own prepacks and then send them on through without much scrutiny from a really independent practitioner.
And that's obviously a diametrically different view from what Singapore and UK, which was a tussle anyway, and to see Australia from a very different lens is, at least academically, a very sort of insightful and challenging aspect. But what really intrigues me about this entire setup is oftentimes you are not looking at localized restructuring or prepackaging necessarily, right? Because I think that's one of the reasons why India is kind of limiting it to a particular number and small claims, as opposed to letting it trickle into group insolvency setups or larger claims where assets could be in different different countries. Now, we were doing a case study, which essentially was that of an airline where the proceedings were actually in the United Kingdom and the assets were in Singapore. There were certain bondholders in New York and unsecured creditors across jurisdictions, but the insolvency proceedings were being conducted in the United Kingdom. Now, let me just add a layer there for you, Emma. If there were unsecured creditors in Australia, and obviously the end goal was restructuring, and that's exactly what was happening as a part of the insolvency process in the United Kingdom, how would you advise that unsecured creditor, and how would the restructuring sort of pan out from an Australian perspective? Now, for the listening audience, I want to say that we've kept it all common law, and let's see what the response would be from an Australian lawyer.
So in this framework, what we have some Australian creditors who are hoping to get some good outcome for them in this restructuring. The Australian courts are quite familiar with cross-border insolvency, and they're usually fairly big fans of cross-border insolvency, and they're content to take a back seat to proceedings in other jurisdictions in the vast majority of cases. So an English restructuring process would have very little difficulty getting recognition in Australia, whether, well, usually under the model law. And the Australian creditors would be left to their rights in that UK restructuring. The Australian court would be very unlikely to intervene and try and do anything to specifically protect the rights of Australian creditors, unless you're dealing with a creditor who for some reason is not able to participate in the UK process. And the main example of that comes from an Australian case called SAD, S-A-A-D, which is our leading model law case, which involved assets in Australia and a creditor in Australia who was the Australian Taxation Office. And as a revenue creditor, they weren't able to prove in the liquidation in the Cayman Islands in that case. So the solution that the court came up with there was to hold back in Australia so much of the Australian assets as were needed to give the Australian Taxation Office a dividend equivalent to what other creditors were able to get in the Cayman Islands liquidation. So it was a deviation from the idea of modified universalism, but it was exercising the power under the model law to provide adequate protection to an Australian creditor. But if we're looking at normal sorts of trade creditors of a large airline that's going to be restructured in the UK, and all of them are entitled to participate in that process and they're being given their rights there, then the Australian court will simply sit back and allow that UK process to pan out. And then there's a very difficult question of enforceability. But if there's nothing that needs to be specifically enforced in Australia, then you won't need any additional orders from the Australian court.
That perspective of cooperation and allowing a proceeding to continue in another jurisdiction clearly means that there is a high enforcement rate in Australia, particularly of territories which are recognized for the purposes of enforcement. It, I suppose, makes it easier for group company insolvencies with what you're saying, but in our conversation, from what I understand, that is not the case. All right, and talk to us a little bit about how the local law deals with group insolvencies and how the model law is sort of connected there, because it's very different from what we've just spoken about vis-a-vis restructuring.
Yeah, so for group insolvencies in Australia, if you're dealing with an Australian corporate group, there are some fairly limited tools for dealing with these sorts of situations. If we're talking about a liquidation scenario, the main tool, or there's a few sections in our Corporations Act that allow for pooling of assets and creditor claims of related companies. They can be pooled together if both companies are in liquidation, and then their assets are treated as the assets of one entity, and the creditors are creditors of that one entity. Now, that opportunity to pool arises where the affairs of the companies are so intertwined that there's a practical difficulty in dealing with them individually and in external administration. We've had that pooling regime since 2008. It was almost never used. There was a little spate of use in about 2011, 2012, and then in the last 12 months or so, it's gotten a bit more use as well. It's one of those sections that people forget exists, and then it becomes fashionable for a little while and gets a lot of use. But it only applies in liquidations. And it only applies where it's just and equitable, and really importantly, if there is an unsecured creditor who hasn't consented to the pooling order and who's going to be materially disadvantaged by the pooling order, then the court can't make a pooling order. So in so many circumstances, that just makes it impossible for the court to use this power to make pooling orders, because if you've got some unsecured creditors that are going to lose out substantially because of the pooling order, it just can't go ahead. Now, there is some more specific legislation to deal with pooling where you're dealing with client monies in a bank account, effectively money that's held on trust. And the courts will take a fairly practical approach to dealing with bank accounts that contain client funds that have gotten mixed on a whole set of separate trusts. If a liquidator comes to court and says, well, I'm unable to unwind all of these transactions, the court will effectively pool them and distribute them amongst the beneficiaries of those trusts. But that's not so much a question of corporate groups as it is a question of what happens when you have a defaulting trustee who's running a whole set of trusts altogether. But that's where pooling comes up a lot in the Australian case law. In the last few years, there's been a new development since 2017 in voluntary administrations where a voluntary administrator is appointed to a large group of companies. And again, this came up in the 10 network voluntary administration. They had dozens of companies, and they ran in the same way that the companies had previously done. They ran a treasury bank account, pair of treasury bank accounts. But that was inconsistent with the duties that the voluntary administrator owes as set out in the Corporations Act. So they had to go to court and ask for an order varying the operation of that part of the Act to allow them to do this. Luckily, the court has a specific power to vary the way voluntary administration legislation works, and they permitted that variation so that those group bank accounts could be operated by the voluntary administrators. And then when the companies proceeded on into a deed of company arrangement, that deed of company arrangement dealt with all of the companies as a corporate group, which is no problem. A DOCA can deal with as many companies as you like, and it can have whatever provisions the creditors are willing to agree to. So you can effectively pool as much as you want and deal with a whole corporate group as if it were one entity if you're doing it within a deed of company arrangement. Now, the same can be said of schemes. It's certainly the case that the schemes that have been used in Australia, I think, have all dealt with sizable corporate groups, and you can have up to 40 or more companies sometimes being dealt with under the one scheme of arrangement or the one deed of company arrangement. It's really just in the liquidation context that Australia will, the assumption will be that each company is to be dealt with individually, and there's to be no mixing of assets and no mixing of creditors' claims unless you meet that fairly strict test for pooling.
Now, Emma, one thing that is pretty clear that there's no aversion to really adopting international standards or international principles in insolvency in Australia. And one of the biggest sort of introductions that have happened has been the group enterprise framework, because it was entirely clear that that there are certain pockets, there are certain concerns in cross-border insolvency, perhaps with tracing, perhaps with issues relating to parent subsidiary, branch office, liaison office situations that were persistent in businesses of today, particularly sectoral businesses. Now, how is the Australian response to the group enterprise framework different from its adoption of the cross-border model law?
Right. We don't seem to have any interest at the moment in adopting the group enterprise framework. Before this lecture, I asked around and did a bunch of research, and no one seems to be talking about it. Group issues like this have just not been anywhere near the top of the Australian reform agenda in the last 20 years. Now, it took us about 10 years to adopt the model law. I think it will take just as long for us to even consider adopting the group enterprise framework. And I think the group enterprise framework is perhaps a harder sell than the model law to Australians. The model law already reflected what we were doing at common law. And under our Incorporations Act provisions, the model law is just a different way of doing the things that we were already doing, whereas I think the group enterprise framework will go a lot further than that and will be a lot harder to get implemented here.
That's a very similar sort of similarly situated situation, but there is, of course, a larger resistance in India to adopt international instruments unless there is something where there is an alignment possible, and that's what happened in the case of arbitration. In the case of insolvency, there is, I think, a lot of hidden trials still left, and I think one of my biggest takeaways in terms of case studies has been the fact that in the Jet Airways case, another big airline insolvency that is being talked about across the globe, there is still no choice of law, right? So there is still a question of enforcement, and there is still a question of how it is going to be restructured from a recognition standpoint, other than the fact that, okay, it's business, it's aligning, and it's the best possible value that you're getting for a particular restructuring across several jurisdictions, which right.
What you've said reminds me of another example, which is from Australia. It's an Australian company, an Australian listed company, in fact, called Speedcast International, but it has operations around the world. It's recently gone through a Chapter 11 process, and because it had a sufficient connection with the US, it was able to get into Chapter 11. So the parent company is listed on the Australian Stock Exchange. It's got subsidiaries around the world. The Chapter 11 process has occurred. There's been no application in Australia at all, no need for recognition in Australia. Australia was able to just sit to the side and watch the Chapter 11 process happen. No one came to the Australian court to try and stop it. So perhaps one of the ways that Australia deals with large corporate groups is to let those restructurings happen in other jurisdictions. Perhaps not ideal for the future, but that seems to be what's happening at the moment.
Well, I think it's at least the first public one for us. So let's see how that kind of pans out and what next steps are. And one of the things that I'm very curious to see in terms of next steps is the suspension of insolvency filings and new admissions that is going to be lifted in 2 days is when the notification expires. And we've been actually a jurisdiction that has been longest in suspension of an insolvency law. It's a year in day after, in 2 days. Now, I know that there are other jurisdictions who adopted this strategy, including Australia. In Singapore, however, as another jurisdiction which suspended the insolvency law, they came out of it with lesser liquidations and more restructuring. How has the position in Australia been different?
So we brought in some temporary COVID relief in March of last year, and it ran through to the end of the year. So we had 9 months. And during that period, we increased the amount for a statutory demand to be issued to a company. It jumped from $2,000 to $20,000, which was a huge jump. And we extended the time that a creditor has to respond to a statutory demand from 21 days out to 6 months. So we didn't just put a hold on all types of insolvency, we just stretched the time periods and increased the amounts. And we put in temporary provisions that meant directors weren't going to be personally liable for insolvent trading during that period from March to December of last year. So all of that temporary relief expired at the end of December. And now the view is that the small business restructuring framework and the small business liquidation framework is all the relief that anyone gets. And Australia has done fairly well economically despite COVID. We've been blessed not having the numbers of cases that we've seen in so many other countries. And as a result, the government has been trying to haul us back to normal functioning with no more exceptions. And there is a worry that we're going to have a rush of small business insolvencies, but it hasn't happened yet. So we're all just sitting on the edge of our seats waiting to see what happens. And so far, our largest airline, Qantas, has just managed to keep afloat. So I think it's very much watch this space when it comes to anything in the tourism sector. Is the sector that's still very hard hit in Australia.
I mean, it's also one of the things that is being considered, I suppose, as you and I speak in India, where do we need sectoral reforms? And I think that is perhaps the most important thing that needs to be looked at, because numbers of our insolvency cases have clearly indicated that there are certain sectors where there are restructurings that are possible more, and there is a less move towards liquidation, whereas there are certain sectors where, particularly say services and EPC sectors, where there's going to be absolutely perhaps no restructuring or saving that takes place, because it was the same situation pre-IBC, and I would suspect that it becomes worse now. But one has to just wait and watch, as you say, and I think all jurisdictions coming out of COVID will obviously have to look at a lot of frameworks for small and medium scale, as India is doing, and as Australia has done, as the US has also done with its Small Business Reorganization Act. And looking at certain pockets and diversification of laws, I think, is just the next step. And that's a very sort of thought-provoking note to end and wrap this lecture on, Emma. I want to categorically thank you and Insol International and all the other speakers who've agreed to have this conversation and give these lectures, because one of the biggest challenges in a space like insolvency and bankruptcy has been the fact that practitioners and academics don't really talk to each other in India. And I think as a person who switched over, one of my biggest, I think, goals in life has been to reduce that divide, and to have people like you come on board who have bridged that gap is a huge inspiration to people who want to sort of understand what is the reason for this particular policy or reason for this particular law. And it is in fact a notion which is waiting to be discovered. And I hope that the 10th set of lectures that have happened, and 5 of them with fellows of Insol International, has sort of created the starting stone to build archives and knowledge which is open access and available in the study of insolvency. So I want to thank you very, very much for spending this hour. I know that the tourism sector is shaky right now, but perhaps we could lend it some money by trying to bring you to Sonipat, India, because I know you've never been.
Yep.
Perhaps not for tourism necessarily, but to see the campus and meet me. And I'm very grateful for this time. To our listeners, thank you very much. We are real-time responders of emails, so please feel free to write to the speaker, write to me. Perhaps not back to the speaker about meetings or internships. That, I apologize in advance for that, but it is obviously a necessary consequence. So
Oh, well,
thank you very
I'm glad to hear that it'll just prove that people were listening.
Oh, they're listening, and they will listen, because, as I said, it's public access. And I want to say thank you, and I want to wish you a good night, because I know it's very late for you.
It's been a pleasure. Thank you.
Bye, Emma. Thank you.